Hey guys, Matt LaRosier here with Firearms Policy Coalition, bringing you another weekly update, just to make sure you have all the latest information on everything affecting your right to keep and bear arms. First up, Virginia's first red flag seizures. We have news from Virginia where information has come out about the state's first use of its brand shiny new red flag law. I'm sure they were just so excited to get out and test it. The incident occurred in mid-July where police detained an allegedly suicidal individual in a parking lot, seizing a few firearms from him. This person was not present when the judge held the red flag hearing, and the judge issued an order banning the individual from having firearms for 6 months. That's half a year, folks, the maximum time permissible by the state law. Look, there's a lot of moving pieces here, but taking someone's rights without them even getting to present their case for the maximum time doesn't exactly smack of due process, especially where there's no crime alleged. You have to remember here, we're talking about taking away somebody's civil rights. It's a big call, something usually only reserved for serious convictions after proper due process and a trial. It's not something we do just to be on the safe side. Next up, sheriff says it won't not enforce anti-gun laws. Over in Indiana, we have news from Johnson County, where the sheriff and county commissioners have announced that they will no longer use any county resources to enforce laws that infringe on gun rights. Sounds dope, right? Well, not so fast. It turns out the county still plans on enforcing all gun laws already on the books, like carry permit restrictions and restrictions on automatic weapons, that type of stuff. It's a step in the right direction, but they're still falling short. Any infringement, no matter how small or inconvenient, is still an infringement. It's important, guys, to read the fine print when stuff like this happens and let your representatives know that our rights are already overly restricted. We shouldn't let them get a pass to say, oh, well, we're just going to enforce those infringements that we're already comfortable with. That's not protecting your rights. What would be better would be to say, well, we aren't going to enforce any laws that involve the simple possession of a weapon. That's principled. It means that where no one's hurt, there should be no real consequences. That kind of stuff would make sense, and that's why we need to ask for it. Court says gun store has standing. We have a new decision from the Federal Fourth Circuit Court of Appeals. This court oversees Maryland, Virginia, West Virginia, and the Carolinas. A decision came down involving Maryland shall issue v. Hogan, who's the governor of Maryland. In the decision, the court explained that the lower court improperly dismissed one of the plaintiffs, who was a gun store. In the decision, the Fourth Circuit said that the gun shop did have standing to sue on behalf of its customers, and that it had standing because it was able to demonstrate that Maryland's handgun licensing scheme caused definite economic harm to the company. Makes sense, right? This is good news for businesses in the gun industry and their customers because it clarifies the ability to challenge laws more frequently. Now a little further west, Wyoming Supreme Court won't hear students' case. In Wyoming, the state Supreme Court has denied a university student's appeal from an arrest for criminal trespass. The plaintiff was a student at the University of Wyoming who was attending the state's Republican Party convention. When officers asked him to leave because he was carrying, he refused and was then arrested and charged with a misdemeanor. The student claimed in the lower court that the state laws prevented the local governments and political subdivisions from effectively creating gun control laws. Now, to get around that, the trial court judge decided to claim that the university was an alter ego of the state, so it had the power to act in this way. That's a pretty wild conclusion because of the way Wyoming defines political subdivisions. Nonetheless, the state Supreme Court declined to hear the case 3-2, meaning the alter ego decision stands. Now, back over in Maryland, a Maryland cop steals dead man's guns. Some news came out about the Anne Arundel County Police Department. One of their officers responded to a call about a dead body back in April and allegedly decided to steal some of the guy's guns and other property. On Sunday, the officer, Corporal Jacob Miskill, was arrested and charged with multiple counts of burglary and scheming to commit theft. While the department condemned Miskill's actions, this reminds me about how hard it is to hold government agents accountable when they do something bad. Speaking of that, developments in qualified immunity. On Tuesday, Judge Carlton Reeves of the Federal Court for the Southern District of Mississippi released his opinion in Jamison v. McClendon. In the Jamison case, Officer McClendon pulled over Mr. Jamison and held him for over 2 hours. McClendon lied about the reason for pulling him over, made multiple requests to search his vehicle, and even called in a canine unit to search the car. The search, of course, turned up nothing, and all Mr. Jamison got for his trouble was $4,000 in damage to his vehicle. Yikes. Now, while this case doesn't squarely address gun rights, it involves a terrible doctrine developed by the United States Supreme Court that certainly affects us and our gun rights. The High Court developed a doctrine called qualified immunity, which prevents people from successfully suing government employees when they're acting in an official capacity unless they did something like highly specifically insane. To overcome qualified immunity, a plaintiff has to show that the government agent violated a clearly established statutory or constitutional right, that a reasonable person would recognize that right, and that the defendant did in fact violate the right. Now, because courts have defined what is clearly established incredibly narrowly, this almost never happens. Basically, if the court can distinguish the event in the slightest way from a previous case, you're out. Because of QI, the families of people like Breonna Taylor and Duncan Lemp rarely if ever see justice because local prosecutors often aren't willing to file charges and because of the doctrine prevents them from recovering financial compensation. This has affected every level of government. Once a culture comes to exist that more or less says, hey, do what you want and you'll be fine, you can hardly blame government actors from kind of being fast and loose. That's why if we want to hold our civil servants to the high standard that we're supposed to and have them treat our rights with the respect we deserve, we need meaningful reform. That's why Judge Reeves slammed the doctrine when it forced him to ultimately dismiss the claim against McClendon for the damages he caused. Damages which any normal person, any one of us, would have most certainly be liable for. Well, that's all I've got for you this week. Thanks for tuning in. If you'd like to know more, check out fpcnews.org, where you can find this week's edition and information on our legal and legislative efforts. If you think this content would be important to anyone you know, help us spread the word and tag them in the comments. Also, be sure to check out fpcgear.com, where you can get all kinds of Pro 2A gear like this shirt and the flag, and help keep us in the fight in the process. We've also got this really cool doormat. It says to come back with a warrant. I think you guys will like that. Anyway, as always, keep your eyes on Firearms Policy Coalition, where we're keeping up the fight for all of your rights all the time. I've been Matt LaRosiere, and I'll see you real soon.